Radio 97, it's time to talk some law. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us each and every Thursday. She brings her legal expertise and provides some general advice on the latest hot topics. She's got experience that spans more than 25 years in the area of property and commercial law. She prepares wills as part of estate planning and litigation as well. With us for the second last time this year. Morning to you, Despina.
Good morning, Wayne. Good morning, Brooke.
Welcome back, Desi. So first up, you've got an awesome story for us. This one's a doozy. It's all about a fancy business meeting over a boozy lunch in Sydney into a legal battle. So what happened to Despina?
So yes, I'd love to tell this story because I thought it was quite timely when I read this case and came across it recently, that we are at Christmas time, aren't we? And there's lots of festive lunches and, lots of social gatherings. And I thought, well, this is a really interesting case that was decided in the New South Wales Supreme Court this year. And I thought, well, let's just talk about it a little bit because, yes, the boozy lunch or the social setting / boozy lunch, whatever you want to call it, there might be lots of those happening out there. But this was relating to an agent that met with a potential client, ended up being a client, at all places, of course, in Woollahra Hotel in Sydney, which is a big, well-known suburb in Sydney, Woollahra.
Fancy,
and,
yep.
Yes, and they had a lunch, a get-together, to talk about a potential business arrangement, okay? And there was an agreement through the discussion at lunch of an arrangement between the two of them where the agent would go off and source sites, particularly childcare sites, and would receive a fee to source the sites to then pass over to this client, this party. And so what happened as a result is that the agent, after the lunch, went and did all of those things. So he went and sourced the sites like he said he would and told the client about it, expected to be paid, and there was some transactions where monies were exchanged. But then it got a little bit nasty at some point because the client then wanted to change the terms and to change the payment and the fees that this agent was getting. And so it got into a bit of a dispute between the two parties. And then, of course, they all trundled off to court because the client refused to pay the agent in the end for what apparently was agreed to at this boozy lunch, right? Ooh. So it all comes down to, agreements, oral agreements, what was discussed, what was decided, what was, negotiated at this boozy lunch ended up being, in actual fact, as the court decided, an enforceable contract at law where the client was actually ordered then to pay the agent lots and lots of money that was actually owed to the agent because it came out that, yes, there actually was an agreement formed at this boozy lunch.
Okay, so
Wow.
So regardless of your state of inebriation, you could still find yourself at the end of a boozy lunch having got into a contract that you possibly don't even remember days later.
Well, it's interesting you say that because what the client was trying to assert in the case was that it was unenforceable because he said that the agent was inebriated or intoxicated so much so that he really, wasn't capable of making an agreement or, and forming a contract with this party. So therefore it's unenforceable. I thought, well, that's a, interesting, colourful way of trying to get out of an agreement of some sorts if there was one formed. And interestingly, the court actually said, look, there is no evidence that's been produced to the court. So remember, we've talked before about it's not what you know, it's what you can prove, right? So there's been no evidence tendered to the court that this agent was in fact intoxicated, so much so he didn't know what he was doing. So it might have had a different outcome, perhaps, if there was sufficient evidence given that the person was intoxicated, because clearly you have to have capacity when you make agreements, right?
Yes.
What sort of evidence would the court have been looking for in a case like this?
Oh, well, you could, you and I could come up with some examples, I'm sure, but, thinking off the top of my head, you probably want to have a look at the bill for starters, to see, well, let's see how much alcohol was, consumed on that particular day. What about talking to the staff? If there were regular staff that were there at the time who saw how the parties were interacting, maybe they were refused alcohol at some point. Who knows? So it's about getting that extrinsic evidence at the time, or maybe you took some pictures and posted it on Instagram or Facebook, and
everyone does, yeah.
The champers,
exactly. So, but of course, at the time that you're having this, nice social get together, boozy lunch, that you don't think of these things, do you? You think, look, I'm having a get together with this person, everything's going great guns, we're talking about this arrangement. But nobody really stops to think, am I actually forming a contract then and now with this party that I'm having lunch with? And one of the things that was relevant was, yes, lack of evidence of intoxication, or, that person being incapable of forming an agreement. The other part, of course, was conduct by the parties after the lunch. So I've talked on the show before about if your agreement that you have, whether it's oral or written, is a little bit lacking in what it means, what the parties actually agreed to, what was their intent, the court will look at the conduct of the parties in trying to decipher, well, what did the parties actually mean and what did they intend to do together? Was there a meeting of the minds? What happened afterwards? So that was really important here, because after the lunch, the agent went and did what the agent said he was going to do, where he sourced all these sites, gave them to the client, and there was this exchange of correspondence, and there was an acknowledgement by that client that, yes, you did do these things and you'll get paid, certain fees, and certain fees were paid initially up front. So it's really important to remember that just because you don't actually have a written contract, it doesn't mean that what was discussed and agreed to verbally isn't enforceable.
Yeah, for sure. So your advice, what I'm taking from this is, I guess, you have a boozy lunch if you want to, but if something is made verbal, like some sort of agreement, make sure you have a follow-up email, possibly in writing, or some sort of documentation there to show, yep, this is now in place. Thanks so much for the meeting. We'll do this moving forward. So that way you have a paper trail that backs you up.
Yes, so that's exactly right. And you are spot on. You're going to become a lawyer.
Thank you. Well, it's been 2.5 years now, so I hope I get my certificate soon.
Good teacher, yeah.
Yes, so, very good teacher.
That is the lesson. So if you go along and you have like an innocent get-together, you have a few drinks, you come up with some great idea, let's do this together. Oh, that sounds good. Nothing more happens of it, then fine. But if you then act on it, what you want to do is then say to that person, oh, remember we got together, a couple of weeks ago, let's meet up again, more of a formal setting, and let's try and document what we actually talked about, and let's come up with an agreement that will actually work. Because the agreement, it makes you then think when you're, under normal conditions. Exactly, you said it, about what we want to get out of this agreement. Each party will then think about, okay, well, what do we want to achieve? What am I getting? What are you supposed to do? What are the fees? How are they supposed to be paid? So it's very important that you do that, because if you don't, and then you trundle off and you have this conduct afterwards where you're seen to be doing the things that you agreed to orally, then they will potentially be enforceable, and then you're going to be stuck. So I think a few lessons here, particularly this time of the year, as I said, it is the festive season. So we want to be very careful about potentially what we agree to at, Christmas drinks, lunches, dinners, whatever it might be, and also your conduct and behavior after the meeting. Yeah,
definitely.
Yep. No, good advice. By the way, is boozy lunch a legal term?
Well, I don't know if it's a legal term. It is. But, I call it, if you're going to have a little social get together, AKA boozy lunch, just be, very careful. But, I don't think it'll make its way into the legal books yet.
Not yet. Thank you so much, Despina. And coming up next, what should you be aware of if you're filling in your own will kit? We love a bit of DIY, but maybe not for the wills. That's coming up in just a moment on Talking Law.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.